Hello and welcome to our second webcast focus on optimization of UAE mainland structure following the announcement by the government of substantial winds of change here in the Gulf region. I'm joined this morning yet again by Hermione Harrison. Good morning, Hermione.
Good morning.
So exciting times, huh? We've been very busy with our clients rolling this out, and we thought that we would shine a light on the process, which is how to effectively terminate the relationship with a local agent and a local partner. What are the steps, the process, the do's and don'ts? So before we actually jumped into it, can you perhaps just provide a little bit of input on what these changes means for branches and LLCs?
Sure, absolutely. So as a result of the recent changes to the foreign ownership rules, Yann, a UAE national service agent is no longer required for a foreign branch to obtain a license to operate in the UAE. And then secondly, complete foreign ownership of LLCs is now permitted for companies carrying on an activity on the approved list published by the Departments of Economic Development in each emirate, and provided that the activity is not deemed by a federal committee to have a strategic impact, in which case some degree of Emirati ownership requirements will remain.
Okay, so thanks for this reminder. Now, turning our attention to branches of a foreign company, what is the process to terminate the existing arrangement with a national service agent?
So in simple terms, the process requires both parties or representatives of both parties to the National Service Agency Agreement to appear before a notary public to execute a termination of the National Service Agency Agreement.
Yep.
So once this termination agreement has been successfully notarized, it is then submitted to the relevant Department of Economic Development in the supervising emirate, who will update the license of the branch. This is a simple overview.
So you just mentioned it. Sounds very straightforward to me. So I venture to guess there are some do's and there are some don'ts. So can you walk us through these, please?
Yeah, absolutely. So the process and the success of the process really depends greatly on the willingness of both parties to appear before the notary public to terminate the existing relationship. And it follows that the failure or unwillingness by one party to appear can stall the entire process. So with this in mind, we recommend the following. So firstly, really, it's important to review the existing National Service Agency Agreement to determine the contractual procedure for terminating the relationship. Check also for any final settlement clauses in relation to the annual fee, which is generally payable in consideration for the appointment of the agent. And then based on the contractual review and depending on the nature of your relationship with the National Service Agency Agreement, we really recommend having a conversation about the recent regulatory changes and how the process of termination will be carried out. It's also important to follow the contractual termination process and serve notice as required and within the stipulated timeframe provided in the documentation. We also, and lastly, recommend sharing a draft of the termination agreement, having discussion based on the document with your existing national service agent. So to ensure that the negotiation of any key terms is concluded prior to attending before the notary public.
And what about the don'ts? Are there any?
Yeah, well, it stands to reason, Yann, that you really shouldn't launch the termination process without carefully considering and following the contractual process. And don't underestimate the importance of engaging with your national service agent early in the termination process. And this will help to avoid dispute and friction between the parties that could lead to delay or refusal to sign the termination agreement.
So in other words, prepare appropriately, map out, communicate, execute, and everything should go smoothly. Now, what about an LLC? How can a company today held 5149 transition from this current status towards 100% owned by foreign investor?
So at this stage, what we see is that for existing LLCs who are eligible to transition to 100% foreign ownership, the pathway to achieve full foreign ownership requires the execution of a share transfer agreement before the notary public.
Yep.
This is to transfer the shares from the UAE national shareholder to the foreign shareholder, who may or may not be an existing shareholder in the company.
Yes.
And secondly, submission of the notarized share transfer agreement to the relevant Department of Economic Development. This is to obtain the amended trade license reflecting the new shareholders of the LLC. I should note, though, there may be additional sector-specific regulatory approvals required, but I have to say that this will become clearer as the regulators and the market adjust to the new foreign ownership rules.
Got it. Yet a number of people do not have these sector-specific approvals. So for a large part of people, it should be reasonably straightforward. So like we did for branches of foreign companies, what are the do's? What do you recommend be undertaken to facilitate this process?
Yeah, certainly. So we recommend firstly checking whether your licensed activities are contained in the list of eligible foreign ownership activities. And this list is published by the relevant Department of Economic Development in each emirate. Secondly, consult your specific regulator, and as you say, if this is relevant. An example of one would be the Department of Health in Dubai.
Yep.
And this would be in order to determine and assess any operational implications of increased foreign ownership. We also recommend that you review your existing contractual arrangements with your current UAE national shareholder. And this, like with a foreign branch, is to ensure that the termination process is contractually aligned to your existing arrangements. Putting in place a final settlement and release agreement with your existing local partner will be important to cover and formally conclude any private contractual arrangements you have in place.
Yes.
And then finally, and probably most importantly, use this opportunity to incorporate simple structural enhancements in the process of transitioning to foreign ownership. This can be achieved through the use of a DIFC prescribed company, an ADGM SPV, in combination with a foundation to reduce shareholder risk, increase attractiveness to private investment, and importantly, ensure business continuity at a time of regulatory change.
And that is great because you can really kill two birds with one stone. A lot of people over the years have been interested in enhancing this structure through different tools. And now you can actually achieve both in one reasonably simple step. So all that is very good. What about the don'ts? Are there any with LLCs similarly to branches?
Yes, so much like terminating a national service agency agreement, the failure or unwillingness by one party to appear before the notary public to execute a share transfer agreement can stall the entire process. So we recommend that you don't launch the transition process without reviewing your existing contractual arrangements and engaging with your local sponsor early in the process.
Yep.
And don't miss out on the opportunity, as you mentioned, to implement simple, cost-effective, tried and tested structural improvements.
Now, all this is a very good, I would say, framework. We have already undertaken a couple of these files and are in the process of assisting quite a lot of clients. It's almost scary how many are interested. So let's walk us through one of these cases on a no-name basis, of course. Can you walk us through this first example?
Sure, certainly. So we're using here a case example of an existing LLC that has determined that it's eligible for 100% foreign ownership. So we're assuming here that the LLC is held by an American petrochemical company, and that's 49%,
yep.
and 51% by a UAE national. The American petrochemical company, in this context, is in control of the management and operation of the LLC.
Yep.
So the LLC's core business in this scenario is to conduct the activity of petrochemicals trading. And, excuse me, management has reviewed the list of activities published by the Dubai Economy and determined that petrochemicals trading is permitted to be undertaken by a 100% foreign-owned company. So they've done their research, they're planning the transition.
Yep.
Now they're ready to execute.
Okay, so now they want to. So what should they do?
Yeah, so we recommend that the first step in this transition process is to set up an SPV in the ADGM. This is to be 100% owned by the American Petrochemicals Company,
Yeah.
and to act as a holding company of the shares in the mainland LLC.
Okay.
So once the LLC, the SPV, apologies, is set up,
yeah,
we recommend that they then execute a share transfer agreement with the existing UAE national shareholder to transfer the entire shareholding in the LLC to the SPV formed in the ADGM. So in order to formalize this arrangement, we also recommend executing a termination and release agreement with the UAE national
Yep.
to conclude the private contractual arrangements at that level.
And eventually you end up with this, which has a regional holding in a sophisticated financial center. Could be the DIFC, could be the ADGM. You have the foreign entity abroad, and you have just one single vertical held 100%, which our American friends love because it's better looking on their balance sheet. So what is achieved here? Can you walk me through this?
Sure. So you can see that the split between the operational vehicle onshore and the holding company in the ADGM provides key asset protection,
yep,
and facilitates the ease of investment and divestment without causing business disruption at the operational level. Secondly, the ownership of the LLC is held with the holdco contained in the ADGM's common law jurisdiction. This provides a really sound and internationally recognized basis from which the holdco can access more sophisticated corporate tools, and which could in turn help holdco obtain financing and access investment opportunities. There's also the possibility of cost savings from this structure, Yann. So where there is a transfer of shares at the ADGM holdco level, there will be less red tape compared to the onshore market.
And it will also be much faster because anytime you need a resolution, you actually go down the road to ADGM, and it's digital aside of going somewhere abroad, and you need 3 weeks and super legalization to do it. So effectively,
correct,
the banks will love it too. Lower risk.
Yep, absolutely. So again, eliminating the onshore presence helps a lot.
So that's wonderful. Thank you very much for this walkthrough, and I'm sure we will have many more cases to illustrate going forwards. Next week, we will go back on a couple of these verticals and activity to check the eligibility for foreign ownership, still with Hermione. Hermione, thank you very much for your input this morning. Have a good day ahead.
Pleasure. Thank you.